Hello everyone. In today's video, we will be covering on the Personal Data Protection Act, also known as PDPA. The PDPA is an enforcement act administered by the Personal Data Protection Commission, PDPC, established on January 2, 2013. Please stay with me as I will illustrate more on PDPA in the upcoming slides. The Personal Data Protection Act 2012, the PDPA, establishes a general data protection law in Singapore which governs the collection, use and disclosure of individuals' data by organizations. It should be noted that the examples in these guidelines serve to illustrate particular aspects of the PDPA, and are not meant to exhaustively address every obligation in the PDPA that would apply in that scenario. Let's look at the identity card. As we can see, this belongs to Cyrus. What other information can we find on his identity card? His job title, company name, department ID, email and contact number. The information provided on the identity card is classified as personal data. On September 23, 2013, PDPC issued a set of advisory guidelines on key concepts in the Personal Data Protection Act. Under the advisory guidelines, there are a total of 9 data protection provisions, starting from consent, purpose, notification, access and correction, accuracy, protection, retention limitation, transfer limitation and lastly, openness. Finally, we have the standalone, do not call provision, which is revised on October 9, 2019. Next, let's dive into the two aspects from the care of personal data under the advisory guidelines in PDPA. The protection and retention of personal data. Under this Protection Act, an organization should put in place reasonable security arrangements to protect personal data from unauthorized access, collection, use, disclosure and similar risks. In short, it is the organization responsible for protecting any data that is in their collection. Consequentially, under the Retention Act, the organization should cease retention or anonymize personal data when it is no longer essential for any business or legal purposes. However, if the action for collecting personal data is justified as appropriate behavior, immediately, it will not be served by retention of the Personal Data Act. As for retention for legal or business purposes will no longer be required. Moving on, a short case study of non-compliance with regulation and their impact. Just not long ago, on August 28, 2019, O2, an advertising firm was issued a fine of $10,000 for breaching an offense under the PDPA for failing to secure the personal data of more than 1,000 individuals. This data includes personally identifiable information like name, NRIC number, email address, residential address and their mobile number. Immediately after the issuing of fine to O2 Advertising, PDPC also appointed a data protection officer and put in place data protection policies in practice. Great Eastern can adopt practices, clauses from ISO 27002, Section 8.3, Media Handling. Information storage media should be managed, controlled, moved and disposed of in such a way that the information content is not compromised. This is to ensure that personal information is not compromised due to improper disposal of sensitive information resulting in dumpster diving or leakage of information. Here are some recommended policies in compliance with the requirement that Great Eastern should adhere. Enhance the authentication for employees by changing the login credentials for every employee once every 3 months, including contracted staff. Also, establish a robust group management policy by restricting employee entry to sensitive and confidential documents on a need-to-know basis. It is a mandatory practice for the organization to issue a personal data breach report form whenever information in regards to employees are leaked. If these policies are executed properly, all unauthorized dismissal of personal data from the organization to known, unknown clients and the general public can be avoided. On top of that, seek advices from an information security officer. Regards to the retention of data, some policies must adhere in compliance with the PDPA requirement. It is important to conduct regular inspection on the data stored in the organization because misconduct of data breaches due to the retention of personal data will be heavily taken action by PDPA. There are legal means of retaining personal data. In a sense, for every data collected, it must be sorted accordingly and be labeled with a date for the retention period. For instance, when an employee left the organization, it is no longer needed for his, her data, and thus, his, her must be disposed of permanently. Organizations should leverage network monitoring tools to track the incoming and outgoing network traffic to ensure no data is stored in an authorized location. So what can the organization do to safeguard the personal data of its employees? Step 1. The organization should entrust one person, or more, to oversee and ensure the organization is compliant with the PDPA. The appointed data protection officer should implement appropriate policies for manipulating data in electronic or non-electronic forms, ensure these policies are relayed to employees, and manage any queries or complaints about personal data professionally. Step 2. There must be a purpose for collecting the data and the consent must be sought before any usage. This is important because, in time of technical failure, data may be lost, but happen to know precisely how, when and where personal data is collected and stored will be a huge support for data recovery. Hence, it is essential to review personal data inventory. Step 3. Information, communication and technology security policies, standards and procedures to protect personal data must be implemented, enforced and reviewed regularly to ensure changes in business practices or technological enhancements have been executed within the organization. Step 4. Details regards to data protection policies should be propagated and acknowledged by all employees and contract staff, including subcontractors who handle personal data. In this way, everyone in the organization will be aware of the internal processes concerning data protection and knows how to react accordingly. The final step, conduct internal audits regularly to ensure the organization's policies, standards and guidelines are in line with the PDPA. By executing these 5 steps, the organization will be able to identify possible risks and improve data protection effectively. Now, let's look into the steps that the organization should commit such that retention of personal data will not be violated against PDPA. Step 1. Lending a hand from designated tools such as Eraser, Mini-Tool, Partition Wizard that is capable of overwriting selected files or the entire storage drive. Step 2. Usage of specialized software appliances such as a degausseur machine, which produces a strong electromagnetic field that can destroy magnetically recorded data for electronic media. A common assumption that happens in every organization, that is deleting files and clearing the recycle bin means all the files are destroyed completely. The answer is no. The computer simply hides these deleted files from the user, and certainly, there is software that has the capability in recovering those deleted files. Therefore, step 3, the best approach is to physically destroy the storage device by crushing, drilling or shredding it. Media that do not support overwriting would be recommended for step 3. After that, perform this final step, which is assessing all personal data frequently and discard any files that are no longer required. Next, categorize the personal data and conclude on how long, in particular, it should be retained. Bear in mind, only retain personal data that is affiliated to a business or legal purpose. An additional tip for outsourced IT services: insert frameworks to ensure vendors treat personal data with the same level of security as the organization. Thank you for staying with me till the end of our journey. I hope you guys have learned something from this video. Goodbye.